should not be arbitrary in nature.
Which article of Parampara Constitution also?
Your Lordship,
Which article of Constitution of Parampara says it should be equally distributed?
Your Lordship, it is a basis. It's one of the basic structure doctrine. Your Lordship, it is not an explicit article. It is a basic structure doctrine that states, and we have the relationship between central and state also. Your Lordship, it is also stated that the power should be distributed between both central and state, and that is for the reason we have separate this for state and central and concurrent. Your Lordship. So all these prove that the power should be distributed between both central and state, and it should not be arbitrary. Your Lordship. That's the main contention, because you have formulated a GST council, but that council lacking certain policy decisions, because state is having certain limited access to the recommendation, whereas the central is having the n number of power to make a recommendation, and this takes away their state autonomy. Your Lordship. And
GST council, there is a voting power. States also have voting power, central also has voting power. Decision is taken on 3/4 majority. So it's a consensus, it's a majority vote. So all the state governments, state are represented, center is represented. So how do you say states are not consulted? So the majority voting decision is taken. So where is the federal autonomy or the state's autonomy taken away?
The limited power is granted to the state. Indeed, there is a power granted for the state, but that power is limited to that of the central. That is the contention. The veto power is granted to the central government, and they are making decision. But earlier, before the introduction of 101 constitutional amendment, it was within the ambit of state government. They have taken away the 1854 and 52 and 54, and they have made a substitutional amendment that 101 constitutional amendment in Article 279 will have both central and state government representation, but the decision will be taken away.
There is a dispute resolution mechanism also in the GST council.
Not so
that is just a mechanism provided. So states can also add the grievances if they have one. So that is the one-sided approach here.
Merely grievances and recommendation alone can be done by the state legislature, but with regards to enforcement, it will be the decision of the central government. That is the reason the self-autonomy of the state is being taken. And our Lordship, decision-making authority before the introduction of GST was within the hands of the state under 1852 and 54. But after the introduction of 101 constitutional amendment, the 80 has been replaced and Article 279A has been invoked, and that makes that central government will be the authority. Though you have representation, the final decision will be with the central government, and the state has to. The main motive itself is the state has to be.
There is no such provision in the constitution. It says that central will have the final decision.
But
is that clearly read it out?
the veto power is granted to the central.
That is written in the constitution. Veto power is there.
Yes.
Council, please correct your statement. There is no veto power to the legislatures. Veto power is given to the executive. What assumption he can give. Okay. Then second thing, according to your understanding, what are the elements of federalism?
Federalism concept emerges when there is an equal distribution of power and decision-making authority.
Do Parampara Constitution has equal distribution of power?
With regards to this case is concerned, there is no equal distribution of power. That is the contention.
The same amendment whichever brought by the Parampara Parliament, referring what entry of Parampara Constitution.
With regards to entry 52 and 54 is concerned, it has been abridged.
Please read these two entries.
With regards to entry 52 and 54, with regards to 54, taxes on consumption of or sale of electricity, taxes on the sale of petroleum, crude oil, high-speed diesel, and motor vehicles.
Right. Then 52.
With regards to 52 is concerned, it is being removed from the constitution of Parampara itself.
Right. Is there any similar entries mentioned in 7th schedule list 2 or list 3?
In the concurrent list, now
yes.
with the concurrent list, Lordship.
You can't find.
Lordship, that is the reason, because they are.
So that is what still if you attempted to bring 7th schedule concurrent list, I will encourage you to read Article 254.
Indeed, that even though they have not mentioned in the concurrent list, they have brought a separate amendment itself for the separation of power, for the distribution of power, Lordship, because the 279A itself is meant for distribution.
Council, two things you have to clear very specifically. when the exclusive power, that's what I encourage you to say list of elements for federalism. There should be a written constitution, yes we have. There are division and distribution of power, yes we have 7th schedule. If you say amendment, then again I encourage you to read 368. Do any procedure mentioned in 368 is violated. That's what our brother judge was mentioning.
Indeed, Your Lordship, under Article 368 is concerned, Your Lordship, there are certain procedures at the time of amendment.
Whether all procedures are complied or violated,
Violated, Your Lordship, it is been violated, but the amendment has been already taken place. But we are against the amendment because now the
so
provision.
what ground you will challenge the amendment? That's what our worry.
Your Lordship, it is violating our right because the amendment.
Which right of your state is violated?
Your Lordship, fiscal autonomy as well as the decision-making authority of the state.
Where is the physical autonomy? Which article says you state have physical
Your
autonomy?
Lordship, with regards to the union and state, relationship between union and state.
Which article? Say your article. The constitutional bench go only by whatever power which is given to us.
Your Lordship, Article 246 is concerned about with regards to
246 says what can enact in which entry, that's all.
Indeed, Your Lordship, but that is the article that
You read. When you say which entry of the 7th schedule is violated in furtherance of 246, class 1, class 2 or class 3.
With regards to 246 is concerned, the list, in list 2, entry 52 and 54 is being violated.
Council 246, 1, what does it say? Union can enact laws all about 97 entries of list 1.
Indeed, Lordship.
Right?
Indeed.
246, 2 says what law both center and state can enact on concurrent list.
Indeed, Lordship.
You said there is no entry in a concurrent list.
Indeed,
Right? Then 246, 3 says what state can enact.
Indeed.
Now if you say 246 violated, say which entry of state list violated.
Lordship, with regards to 246 is concerned, it distributes the power of parliament and legislation.
Fantastic. Which entry of your physical autonomy is violated?
Lordship, with regards to 54, that list 254 itself is violated because
54 in the union list. How you will take the power it is for?
Lordship, with regards to union state list, Lordship, state list 52, 52 is 52 is actually taken away, but 54 taxes on sale of petroleum, crude oil, and high-speed diesel.
Okay.
But
What is the connection between freebies and whatever subject you are discussing here?
This is particularly for the second issue, Lordship, with regards to 101 Constitutional Amendment.
Second one where we are speaking.
Indeed, Lordship, 101 Constitutional Amendment speaks about that the GST will be the primary law.
I think I have exceeded. Conclude that.
Indeed, Lordship. Since the decision-making authority is not being granted to the state by the GST Council, and the decisions of the state is not being priced, as well as the recommendations are being just merely a recommendation, and the decision is taken by the central government, that affects the self-autonomy and decision-making authority, and they are also removed the entry 52 and 54, thereby they taken away the law-making authority of the state. Hence, this 101 Constitutional Amendment is violating the basic structure doctrine of the Constitutional Parliament. I will call upon my co-counsel.
Mr. Council, only one.
Indeed.
Don't you think that constitutional amendments towards moving to GST is the need of the hour, because we are moved into globalization after post-1991. What do you think about liberalization and introduction of GST? Across the globe also they are introducing GST. Don't you think it is the need of the hour? And also second question, don't you think the constitution is not a rigid document? It has to be amended with the times of the
Indeed.
need.
Lordship,
And that's all that was.
with regards to the concept of LBG is concerned, at the time of 1990, in the year of 1991, the Union of Parambara was in need of that particular structure to make the economic growth. And the constitutional amendment, this particular case, it was introduced in the year 2017. So the rational nexus between that itself is a contradiction also. Then the GST Council makes a unified taxing system. That is not to be contented. But the thing is, they made a statement: one tax, one market, and one nation. One nation, one tax, one market. So this shows the monopoly of the union government to take matters solely on their own decision. So they don't want to put up the decisions of the state at first. They want the state to abide and expect everything from the central government, and they don't want to respect the recommendations or the grievances of the state government. So that directly violates the objective of the GST itself, is directly violating the federal structure and the basic structure doctrine of the constitution. That is why the petitioner's contention is that it is violating the basic structure doctrine, and if it is necessary and the honorable court deems with that GST is necessary and mandatory for removing complexity, the honorable Supreme Court may, by an order, direct the government to make some reforms in the act that doesn't violate the autonomy or the fiscal decisions of the state government or the law-making authority. Then it can be held valid, Your Lordship. But now the provisions are being so vague and they are violating the basic structure. So we are challenging that 101 constitutional amendment is violating the basic structure and it needs certain reforms. If not, the act can be completely struck down by the order of the honorable Supreme Court. It's an immense pleasure to argue with the honorable Supreme Court.
Council 6 Commission to ours. A very warm greetings to this bench. I am Speaker 2 dealing with issue 3 and 4 of this case. Establish your Lordships. Your Lordships, the third issue is whether apologies for the inconvenience. Your Lordships, the third issue is whether the levy of GST at different rates amounts to a violation of fundamental rights or not. Your Lordships, the counsel for the petitioners humbly submits that the levy of GST at different rates is absolutely a violation of fundamental rights, Your Lordships. Your Lordships, this can be proved majorly under 3 grounds, Your Lordships. Your Lordships, the very first ground of the petitioner counsel is that the violation of golden triangle of the constitution, Your Lordships. And the second
Counsel, what is the maximum rate state can prescribe on GST?
Your Lordships, as now there is 28% of GST has been imposed by the government, Your Lordships.
28.
Yes, indeed, yes, Your Lordships.
28 means 14 plus 14.
Indeed, Your Lordships. But Your
What is the
Lordships,
maximum rate the state can impose?
14 Your Lordships.
14.
Yes, 14 Your Lordships. The council seeks to match up Your Lordships. Your Lordships, here there is a second ground is that there is an invasion of federalism and the GST structure, Your Lordships. And thirdly, there is clear violation of egalitarian taxation policy. When coming to this first ground of this case, Your Lordship, that is violation of golden triangle of the Constitution. The golden triangle of the Constitution refers to the 3 provisions, that is Article 14, Article 19 and Article 21 of the Parambara's Constitution. It is a backbone of the constitutional framework, Your Lordships. Your Lordship, this Article 14, equality before law, ensures that every person shall be treated equally before the law and there will be no discrimination based on the region, race, caste, sex and place of birth, Your Lordships. Also, Your Lordships,
Whether any tax can be imposed 14% for X, 20% for Y, then there is a violation. There is a violation. Discrimination. X, Y, whoever may be, everybody has to pay 14% on a particular product. Where is the violation?
Your Lordships,
Is there any discrimination between people? Mr. X has to pay 14%, Mr. Y, a rich man has to pay 10%, like that?
Lordships, of course there is a case.
Based on sex, religion, birth, language, or education qualification.
Lordships, here there is a clear violation, Lordships, based on the economic criteria, Lordships. Because that is a
Two economic criteria mentioned in all the 3 articles, whatever you have mentioned. Whether 14 speaks, 19 speaks, or 21 speaks. As you mentioned, we speak about race, sex, color, place of birth, religion, language.
Lordships.
Where is the question of economy as a criteria?
Lordships,
When you bring economy as a criteria, what is your understanding on reasonable classification, productive discrimination, or intelligible differentiation? You can continue.
Lordships, that is says that equals should be treated equally and unequals should be treated unequally, Lordships. But
We are
here it is,
talking about people or goods.
Lordships. Beg your pardon, Lordships.
You are talking about people or goods?
People, your Lordships. Because here people is not
People
even
means you have
treated
to answer
equally,
my
Lordships.
question whether citizens are discriminated by race. You have not answered that question.
Lordships, it is within the ambit of Article 14 of the Constitution itself, your Lordships. Your Lordships also.
Council, what the brother is, senior brother is asking is, now you said there are different rates, 0%, 2.5%, 5%, then 12%, right? Now the classification is on the rates depending upon the goods, correct?
Yes.
So if you are going to a 5-star hotel, where the tariff rate, if you are only 7,500 above, then if you eat in a restaurant in a 5-star hotel, you have to pay 18% GST. Same thing, you go to a A2B or Sarana Bhavan, it's only 5% GST. Correct? So here, the legislature has consciously applied two rates, one for a 5-star hotel dining, one for a normal dining where a middle class person will go and have. So where is the discrimination? Is the discrimination with respect to the goods, or discrimination you are saying is for the people? But here the question is, issue raised is different rates for different goods. You are saying that is a discrimination. What senior brother is asking is, where is the discrimination among the people here? Where are people being discriminated?
The same is applicable wherever you go throughout India, except very territory for your people.
Yes, Lordships, because Lordships, of course, there is some discrimination in the goods also, Lordships, because take for an example of water, Lordships. Water, which is natural mineral water or an artificial mineral water, has been imposed 18% of GST, Lordships. So without water, a human cannot live, Lordships. But here, the government what's imposing, that is 18% of GST for a water, Lordships. So the basic
What is
essential.
the value addition in this bottle of water? The water
It's an
is, you are getting water from the ground.
Yes, Lordships.
There is some value addition is made to the water and bottled in this bottle.
Yes, Lordships.
So for that value addition,
Yes.
government is charging GST. What is wrong in that?
But it's not about to the 18% of GST, Lordships, because if the value has been added, it must be reasonably added, Your Lordships. If the government has imposed less than 18%,
Power to make laws. Is it an absolute power or limited power or restricted power?
it is limited power, Your Lordships.
Which provisions of constitution limits the sovereign power to impose and collect tax? Cite the constitutional provision.
Lordship, if it is an arbitrary under Article 14, and if there is no reasonable classification.
Now, where is an arbitrary? As our brother judges are mentioning, you are giving an example of water.
Yes, Your Lordship.
Wherever you buy water bottle, then you have to pay 18%.
of
Where is the
GST.
discrimination?
Of course, the 18% of GST itself are arbitrary, Lordships.
Then where is the indication for they should not suppose to fix 18%? Can you say 2%?
Indeed, it must be reduced, Your Lordships. That is
Who,
what the.
who will suggest it should be reduced? Where is an indication? Where is a source power? Where is an authority?
Lordships, the traditional contention is that the classification of the 5 slab rates, that is 0%, 5%, 12, 18 and 28% itself, the goods and services not properly classified into such 5 slab rates.
Where is the data for you to say proper or improper counsel? Say which are proper according to you.
Lordships, even this 5 slab rate itself, there is no proper report to classify, Your Lordships. So that is what the
That's
contention of
what
it.
we ourselves understood. It's a sovereign power. They can do anything.
Are
But
you aware of?
They can do anything but subject to the reasonable restrictions as well as the arbitrary.
Are you aware of revenue neutral exercise?
The council is
Revenue neutral exercise.
council is unaware about this.
And you said reasonable restrictions.
Yes, sir.
Reasonable restrictions only in the name of freedom. You are speaking about right. Whether you want a remedy under 14, 21 or 19.
Both the 14, 19 and 20, 21.
How you
So
will,
that is what the violation of code and bylaw.
how you will equate 14, 14 and 21 with 19? Could you equate?
Yes, Your Lordships, Your Lordships, here, Article 21 guarantees the right to life and personal
No,
liberty here.
please understand my clarifications. Could you equate 14 and 19 with, 14 and 21 with 19?
Because Your Lordships, here, right to life is comes under the Article 21, Lordships.
Okay.
And there is a clear violation of right to freedom of
I
right.
am not at all asked whether it's violent or not. Whether 14, 19 and 21 are in a similar footing or different footing.
It's of course in the similar footing, Lordships.
Is
That
it?
is what the case mentioned in Manada Gandhi versus Union of India case, Lordships. Here the Supreme Court held that the Article 14 mandates the fairness in law and procedures, Lordships. this comes under the chain link between Article 14, 19 and as well as 21 of the Constitution. That is what Manava Gandhi versus Union of India case is.
Was the case decided against the administrative decision or legislative decision?
It is against the legislative decision.
Is it? What legislation was challenged?
Your Lordship, it is comes under the administrative decision.
Fantastic. Are you speaking about legislative or administrative?
Now I am speaking about the legislative.
How you will cite Manava Gandhi versus Union of India 1978 here?
Indeed, Lordships, but
Okay.
there is a link. Actually, the council wanted to state that there is a link between 14, 19, and 21 Lordships. So that is what the council wanted to clarify about the golden triangle.
14, 19 is
Yes.
rights, 19 is freedom, that we have reasonable restriction.
Indeed, Lordships. The Lordships also in the case of Skill Auto Solutions Private Limited, this is Union of India, the Supreme Court upheld the different GST rates. The taxation policy is the government's prerogative. However, it left the door open for challenging the arbitrary classification. As the council stated that there is clear arbitrariness in this classification of the slab rates, Your Lordships. So, it is comes under the arbitrary classification, Your Lordships. Also, Your Lordships, the luxury goods is being yes, Lordships. The luxury goods is being taxed at the higher rate than the essential goods, Lordships. But it could be argued that there is a violation of equality and there is no clear justification of this disparity, Lordships. Lordships, the council would like to state that the KK Verma versus Union of India case, the Supreme Court dealt with the unreasonable nature of taxation and held that the
Memorial page number 20. 3.2 submission. There is no violation of 19(1)(g) of Indian Constitution. Reading
page number 20.
page number 20. Sorry. Can you?
Much appreciated, Lordships.
I have wrong.
Indeed, Lordships. Lordships, on the second ground of the petitioner council is that, Lordships, that is, there is a clear invasion of federalism as well as the GST structure, Lordships.
You can skip federalism. Already we clarified last for our brother council.
Yes, Lordships. Then I am coming back to the same first ground, Lordships. That is, here the essential medicines has been imposed 5% of GST. And the life-saving medicines also imposing 5% GST. And this homeopathy, allopathy medicines has been imposed 12% of GST, Lordships. Even a band-aid has been imposed 5% of GST, Lordships.
All these are rationalization of tax rate. Why do you disturb Supreme Court for this issue? Rationalization of tax rate, legislation will take appropriate time, they will take a call.
Indeed, no, Lordships, because
What is
this
the
rationalization
violation? What is
itself
the
a violation.
Yeah.
So, Your Lordships, this rationalization itself a violation, Lordships, because this is never rational. This rationalization is not classified properly, Your Lordships. So that is what the contention of the petition is, Lordships.
All the states are members of the GST Council.
Yes, Your Lordship.
So every state minister and secretaries are participating in the GST Council meeting.
Yes, Your
They are party to the decision of the GST Council. And that is being implemented by the executive. Then what is your problem?
But my co-counsel already has argued that there is a clear invasion in the central power, Your Lordship. So here central has
That
been.
is regarding your issue only. I am talking about your issue only, not co-counsel issue.
Indeed, Lordships, but the second ground is that the invasion of
I am
federalism
talking
as well
about
as the
that
GST
ground
section.
now, whether levy of GST at different rate amounts to violation of fundamental rights.
Yes,
That's
Your
only you are
Lordship.
speaking.
Yes, Your Lordships,
I am
but the
asking only on that.
yes, Lordships, but coming to the second ground, that is the invasion of federalism and GST has been comes under this third issue also, Lordships. So here the Union of Parampara, Lordships, that taxes are matters shared between the state and central, Lordships.
No, you are talking about different rates.
Yes, sir.
Don't go to sharing of income. Different rates, you are challenging the different rates.
Yes,
That
sir.
is violation of fundamental rights.
Yes, sir.
I think I don't see any violation of fundamental rights.
The council will not explain with an example, Lordships. Here, the gold and diamond, Lordships, which is imposing tax only for 3%, Lordships, that is 1.5 and 1.5. The government is thinking that even gold and diamond is necessary rather than the common essential elements, Lordships, because here the water has been imposing 18% and the gold and diamond.
Total case
Yes,
rests on two issues. One is there is the parties are favoring people, so the scheme has to be scrapped.
Yes, Your Lordships.
Government is favoring only jewelry purchase and other things, so this rates to be violated.
Indeed, yes, Your Lordships.
What is this?
Because this is a violation of fundamental rights of the common people, Your Lordships, because the salus populis suprema less esto, Your Lordships. Welfare of the people is highest, Your Lordships. But here, the welfare has been absent, Your Lordships, because the gold and diamonds has been imposed only 3% of GST. But whereas the water has been imposed 18% of GST. So whereas the welfare goes, Your Lordships. Also, when coming to this
Where you are sitting now?
Lordships,
Where you are sitting now?
the council has been explained, it's not really the position, Lordships. As the bench has
No,
been.
you are studying in government law college, right?
Indeed, yes, Your Lordships.
Education is provided by whom?
Indeed.
I am not asking which college from you. You are studying in a government college, what
Indeed,
field?
indeed, yes, Your
Who
Lordships.
provides you education?
Government has provided.
Government is providing. How government can pay electricity bill, salary, teacher salary, etc., books, etc. They have to collect tax, no?
Yes, Your Lordships.
When you want to abolish all the taxes, that's what we clarified, what is being proposed from the landlord.
Yes, the government has to collect the tax, which is, but not an unregulated.
GST at different rates amount to violation of fundamental rights.
I think your answer should be, challenge is only rationalization, not abolition of taxes.
Indeed, yes, Your Lordships, there is no abolition of tax, but the GST tax slab rate must be reduced, Your Lordships, and also this 5 slab rate has been never classified in proper way, Your Lordships. So that is what the contention of the petition.
Am I correct to say that the violation is a class violation because it is why state is discriminating between the haves and have-nots?
Yes.
The have-nots are forced to buy a water at 18% tax, and haves can readily pay.
Indeed, absolutely, Your Lordships. So that is what the petition's contention is, Your Lordships.
Can the Supreme Court
Yes.
fix the rate? Are we having the power or the information or data? Just issue the rate. Can we say no, let it be 5%, let it be 2%? Can we decide as Supreme Court judges? Is it our domain?
Yes, Your Lordships, indeed no, Your Lordships, because Your Lordships, the Supreme Court may give guidelines or make any recommendations to the GST Council, Your Lordships, because here legislature.
Why should we do it? Because that is what state is elected, no?
Yes, Your Lordships, under Article 141 of Constitution, the court may give an order, Your Lordships, but it is in recommendatory nature to the GST Council so that they can provide.
Council, our brother judges are very strong to make you to understand. Can judiciary wing of the constitution make any interferences with the legislative or administrative decisions?
Indeed, yes, Your Lordships. Judiciary can enter.
Can we interfere?
Yes, Your Lordships.
Tomorrow,
The judiciary can interfere with the.
order
executive.
passed by us.
Yes.
First thing is to be, order has to be enforced.
Yes, Your Lordships.
Tomorrow, assuming we are passing an order to slash this rate and so and so rate.
Yes, Your Lordships.
If the order is not obeyed, what is the outcome?
The court may proceed with a contempt of court proceedings.
They will pass an order to amend the rates prescribed under the GST Act. What will happen?
That is subject to the Article 360.
The same thing happens with the election commissioner appointment also. Supreme Court has modified the
But
appointment
those
process.
amendments subject to Article 368 Your Lordships with the ratification, Your Lordships. So without this ratification, there will be no amendment, Your Lordships. If the Supreme Court gave guidance.
Council, you have mentioned about 141.
Yes.
What is
It
the
is
text
binding
of 141?
It is binding effect of.
What is binding effect? What is the exact phrase used in marginal note of 141?
Law declared by the Supreme Court.
Law
to be
declared
binding
by.
all the Lordships.
Law declared by. When the question of declaration comes, is it under the advisory, is it under the regular jurisdiction?
Beg your pardon, Lordships, come again.
Whether the declaration will come under the advisory jurisdiction or regular jurisdiction?
Come under the regular.
Regular jurisdiction.
Yes.
Through regular jurisdiction, can we give any advice or opinion?
Yes, of course, the court may.
Where is the power?
Under the same article of Article 141, Your Lordships.
Law declared by
Law
The
declared
courts-
by the Supreme Court binding all the Lordships.
only courts. Put it by the legislature and executive. That's what our brother was clarifying with you.
So that is what the council said, the court may can give recommendations and the guidelines.
Can we give a recommendation? That's what I asked you to make a distinction between declaration and recommend. Whether both are synonymous? It's not. Then where is the power to us?
Okay, go to the next issue.
Okay, so the final issue. So to save your time, again you mentioned about this thing, LPG. What is the allowance of Palco's case in our page number 25, footnote number 24?
Balco employs
What is the allowance of this case for our problem?
Yes, it is relevant, Your Lordships.
What is the relevant? What is the facts of the case in Palco's case?
Your Lordships, here the relevance is nothing but the national economic interest, Your Lordships. So that is what the definitions here are explaining to the court.
Do any concept of taxation, freebies, GSTs were involved in this particular case? Have you read the judgment? What is the crux of the judgment?
Your Lordships, there is no involvement of GST or income tax.
Okay. And what was issued what?
The council wanted to state that there is an economic interest of this nation, Your Lordships.
What was the decision taken by the government?
The court held that the economic reforms are essential for the national growth, Your Lordships.
Okay. Can the court interfere in the economic reforms of the government?
Of course, if it is an arbitrariness, Your Lordships. Of course, if it is an arbitrariness and there is a violation of any fundamental right, the
Still,
court may interfere.
you learned counsel and your brother counsel are not making a demarcation between policy and law. Here we are speaking about law or policy.
Speaking about the law, Your Lordships, not the policy.
Which law involved? Say name of a law.
But here, Lordships, under Article 279 capital A, the GST Council may give a recommendation. Based on that recommendation, this slab rates and the laws are has been imposed in Lordships by the day-to-day basis, Lordships. So that is what the contention of the petition, that this clearly violates the fundamental rights of the citizen, Lordships.
GST council gives recommendation.
Yes,
Then
Lordships.
the legislature will pass suitable amendment. Immediately after GST council's recommendation, the law doesn't come. The legislature will make suitable amendments.
Yes, Your
And it
Lordships.
is a proper procedure established. So that is the violation.
Yes, Your Lordships, but Your Lordships, here, after that recommendation, Your Lordships, they are passing a notification and implementing the same, Your Lordships. But here, without any reasonable restrictions or without any clarification, they has been imposing, Your Lordships. So that is what the contention of petition, Your Lordships. And since, Your Lordships, this GST Council's recommendation can be reviewed by the same judiciary, Your Lordships. That is what my co-counsel has been already stated the case, Your Lordships. Your Lordships,
Okay, counsel. Finish fourth issue.
the council want to know the court issue, Your Lordships.
Make it fast.
Much
It is your
obliged,
turn.
much obliged, Your
So this is
Lordships.
the learned counsel has taken much time.
Indeed, yes, Your Lordships. Your
So
Lordships,
before going to start, what is the interface you are making between 19(1)(g) and 301 to 307 for your fourth issue?
Your Lordships, here Article 19, that is right to freedom of trade and commerce has been affected, Your Lordships. Also here Article 31 guarantees that the free trade, commerce and intercourse throughout Parambara. Here GST complaints recommends that is multiple tax slab rates, Your Lordships. This has been imposed to the small business industries also, Your Lordships. So here the small and medium enterprises has been affected, Your Lordships, as well as the consumer, Your Lordships.
That's a threshold exemption. Up to 20 lakhs turnover annually, they don't have to register.
Your Lordships,
Only beyond 20 lakhs only the registrations, but the small businesses are protected.
but it is not about like if the small scale and enterprises, it's not only encouraging 20 lakhs, Your Lordships, because even a small scale enterprises has been earning more than 20 lakhs, Your Lordships. So that is, then they comes under the GST, Your Lordships. Here, the small scale industries enterprises and the large scale enterprises has been treated equal, Your Lordships. But how can the small scale industries can be imposed higher rates of GST, Your Lordships? So that is, there is the right to trade and commerce has been affected, Your Lordships. Your Lordships, also there is a double taxation, violation of double taxation and the burden of individuals, Your Lordships. Here the income tax, that is particularly on dividends and the capital gains, here has been the dividends and the capital gains has been violation comes under the double taxation, lordships, because they are paying income tax as well as the GST, lordships. So this leads to double taxation, lordships. Lordships here.
Well, income tax is on income, whereas GST is on supply of goods or service. How can you treat both as double taxation?
But this
If the income is taxed twice or the goods is taxed twice, you can call it as double taxation.
yes, your lordships.
That is a different concept. For your earning income, you are paying income tax. For purchasing goods or services, you are paying the GST. That is double taxation comes here to play.
But your lordships, this tax has been paid by the same citizen, lordships. So that is what the double taxation here. The same person has been paying income tax as well as for the same business he has been paying GST also, lordships. So here the double taxation plays here. He has been paying more tax, lordships.
GST is paid is from pocket or GST is collected and literally given to the government? Who is paying the GST? Is it by the company which is owning or is it by the people?
Both by the company and the owner.
Who is paying income tax?
Your lordships, even the income for the businesses comes under the income direct tax, your lordships. So if a person paying a income tax under the head of business, he has been paying income tax, lordships, and both they are paying for the GST also, lordships. So this is clear violation of our double taxation, lordships. Your lordships, this
Double
means
taxation
this
means
means that
if the same income is taxed twice, it is double taxation.
yes, sir.
If the same supply of a service is taxed twice or the goods is taxed twice, it is double taxation.
Yes, sir.
Here it is not double taxation.
Lordships, here I am engaging in a business and I am paying income tax as well as paying the GST,
You
lordships.
will be
So that
paying
is-
municipal tax also.
Yes, your lordship.
So double taxation.
You are paying water tax, you are paying electricity, you are paying road.
Road tax for your car.
Even whenever we are going, we are paying that tariff, we are paying many. And in that case, government card.
Yes, your lordships, because that is a local body has collecting the tax, your lordship.
No, are they not a state?
They also come
Local
under
body, are they
the
part of
they also
state?
comes under the purview of state, your lordship.
Local bodies are state or instrumentalities?
They are comes under the purview of state, your lordships, under the definition
it?
of state under Article 12 of the Constitution, your lordships.
Okay.
But
Then, what Article 91G say?
lordships. Apologies for the inconvenience.
No. You are only a council, don't get any apology, you can read it.
Your lordships, here under Article 19(1)(g), to practice any profession or carry any occupation, trade or business.
Okay. So if you enroll as a lawyer, you will get some fee.
Yes, sir.
Okay, whether that particular fee is subject to what? Is it the professional tax or income tax?
Is subject to the professional tax.
Then you have no authority to pay income tax. Or you will pay both.
Professional tax comes under the head of income tax.
Income.
Income tax in the name of
Right?
profession.
Suppose if you have a business,
Yes, sir.
okay, you are
But
earning
as
something.
an advocate, I cannot carry out any business relationships.
You are?
As an enrolled advocate, I cannot carry out any business in my name.
Okay, skipping your practice you are earning. So whether that earning is subject to tax or not?
Yes, indeed, it is subject to the tax.
Okay. So whether your freedom
Yes.
as a council not enrolling, okay, is it absolute or restrictable?
Relationships, it is restricted taxes.
Restricted freedom, right?
Yes, sir.
So do you say that restricted freedom is a violation of Article 19?
Relationships come
Or
under-
would you said there is a restricted freedom. When now your freedom is restricted, will you say, because you yourself said you are lawyer, you can't do any business. Could you say your life is violated or you are violated with Article 14?
Lordships, if I am earning in this particular advocacy, why should I go for any business, your lordships? So
You have
that
a
is-
choice,
Yes,
but
sir.
some other better people who want to do both.
That is what the council contention is. I am speaking for the beggar also, lordships. Here, this the right to trade and business has been violated, lordships,
No,
because
whether
he
that
made-
particular restriction is in the violation of 14 or 21, that's what I want to get from
Of
you.
course, it is in violation of 14 lordships, as the council already stated.
Then
and
why
clearly
none,
between-
why none lawyer challenge the advocates are? Without doing business, I can't do my legal profession.
Lordships, but already the advocate has been carrying out a profession, lordships. So there is no need for any other.
No, according to you, it's no need because you are self-made, you are a senior counsel, you are earning. Some other people want to continue. Can they challenge by referring 14 or 21? Life is violated, equality is violated.
Indian
Why?
lordships, they cannot.
Why?
Lordships, this in this particular advocacy field, this will lead to undue influences, lordships. So that is why the government has been regulated, lordships.
That's
If a
what.
person
Whether
doing
that
any
particular
business-
regulation is
Yes.
within the parameters of Constitution of Parampara or not.
Yes, of course, it
Can
has
ask
been
me.
comes under the parameter.
When that is accepted, then what is the issue with respect to whatever compartment which is made by the sovereign? You are saying 14 and 21 is violated. That's what I want to establish. Good.
Yes, Your Lordships. Your Lordships, when coming to this ITC concept, here the cascading effects can be reduced by the cost of ITC, Your Lordships. But here, if the GST has been already has been increased, Your Lordships, here the consumer has to pay in the ITC concept, Your Lordships. So here the goods cost has been increased. Also, if the goods cost has been increased, there will be no consumer, Your Lordships. If there is no consumer, and there will be a clear violation of trade and business, Your Lordships. Because I am a businessman starting my business, and the government has been imposing more GST. then how can
But during the budget presentation, Honorable Finance Minister giving a different. So last 5 years of GST introduction, we are getting this much crore. Even out of 1 lakh taxpayers, 99.99
all
are
those
paying.
money, yes, Your Lordships, all those monies are violation of the fundamental rights of the people's money. Your
So
Lordships.
according to
Yes.
you also, collection of tax is a violation of fundamental
No,
rights.
Your Lordships, the collection of tax is not a violation, Your Lordships, but collection of more tax is a violation, Your Lordships.
Okay, where is an authority to say which is more or less?
Your Lordships, it is the duty of the respondent council or the state to give the proper record or a proper report to submit before this honorable
Counsel, see your issue, what is the question of law frame?
Lordships, here the question of claim in the court issue is that
Whether the levy of both income tax
Income
and
tax and
GST violates
GST
the economic interest of the nation.
Yes, Your Lordship.
Economic interest, how is Supreme Court the proper form? It violates basic structure, if it violates any fundamental right, okay, violates the economic interest of the nation.
Yes, Your Lordship.
Okay, economic interest, then you don't elect these leaders, you elect some other party who protects the economic interest. Some other policy makers, you elect them and bring them to the power. How can we give a ruling on this point, whether it affects the economic interest or not? Are we judicial forum or are we supervising the parliament?
Your Lordship, it is a judicial forum, Your Lordship, but
The
here the
question of
economic
frame is
interest.
wrong, the question of knowledge of frame is wrong.
Indeed, no, Your Lordships, because Your Lordships, here this both levy of GST and income tax firstly is a violation of national interest, Your Lordships. That is the council's conditions that in the case of Vodafone International Holding BV vs. Union of India, the court upheld that the tax domestic economics activities and the retrospective taxation should not harm investors' confidence, Your Lordships. But here there is clear violation of Article 19(1)(g), Your Lordships. Also, it is highlighted the importance of slab tax policies for long terms with economic interest, Your Lordships. So here, this huge tax rate has a violation of economic interest, Your Lordships, because they are violating the people's fundamental rights and by which the economy has been cannot be raised, Your Lordships. So that is what the contention of the petition is, Your Lordships.
Yes, counsel, move to the
Much obliged, Your Lordships. Therefore, the right of issues raised, arguments advanced, authorities cited, the counsel for the petitioners hereby humbly prays to adjudge that the petition filed is prima facie valid and maintainable, and to declare a taxpayer has the right to question the appropriation of tax money for the utilization of PV schemes. Secondly, the 101 Constitution Amendment violates the basic structure of the Constitution. And thirdly, the levy of GST at different rates amounts to violation of fundamental rights. And finally, the levy of both income tax and GST violates the economic interest of the nation. So it's an immense pleasure for arguing this honorable Constitution bench, Your Lordships. It's much
We are pleased to listen from you. Thank you.
Council humbly seeks permission to approve. Warm greetings to the bench. This is the council appearing on behalf of the respondent, in the matter between Parampara Taxpayer Association and State of Nilnadu versus Union of Parampara and others, Your Lordships. Your Lordships, if the Honorable Court is well versed with the facts, the Council seeks permission to proceed with the arguments advanced. Much obliged, Your Lordships. Your Lordships, before beginning with the arguments advanced of the first issue, the Council would like to contest the jurisdiction on which the respected petitioners have approached before this Honorable Court, Your Lordships. Your Lordships, since it involves two important petitioners, Your Lordships. Firstly, Parampara Taxpayer Association and secondly, State of Nilnadu, Your Lordships. When it comes in case of Parampara Taxpayer Association, the law and councils of the petitioners are entitled to jurisdiction under Article 32. But when it comes in case of State of Nilnadu, they have to approach this Honorable Supreme Court under Article 131, Your Lordships, and not under Article 32, Your Lordships. As well as the law and council of the petitioners have claimed about Article 139A, Your Lordships. That will not be applicable in the present matter since there is no case pending before the High Court, Your Lordships. Thus, the Council humbly submits that on which the law and councils of the petitioners have approached before this Honorable Forum will not sustain the present matter, Your Lordships.
It's only a technical issue. So the procedural issue, then why should be taken as a...
Much obliged, Your Lordship. It is just for the contention, Your Lordship. Now the Council would like to move forward to the arguments advanced of the Council.
Yes, Council. One more addition in the last paragraph of the compartment is clearly mentioned. So both the cases are clubbed. Okay? So that's why we need to make any decision in our standing in 32 or 131 it's immaterial.
Much obliged, Your Lordship. Your Lordship, with regard to the arguments advanced of the first issue, that whether the taxpayer has the right to question the appropriation of tax money for the utilization of PV scheme, Your Lordships. Your Lordships, the Council on behalf of the respondent most humbly submits that the taxpayer has no right to question appropriation of tax money, Your Lordships, since there exists no element of quid pro quo between taxpayer and authority. Your Lordships, the concept of quid pro quo is something for something. But when it involves the matter of taxation, since taxation is a much obliged, Your Lordship.
When there is a question about legislative competence, the petitioner has the right to invoke Article 32.
Much obliged, Your Lordships. Your Lordships, with the Council seeks pardon of this particular question, Your Lordship.
Pardon?
Pardon, Your Lordship, the question of which.
When there is a question about legislative competence, the petitioner has the right to approach Supreme Court on Article 32.
Much obliged, Your Lordships. Acknowledging the same, the Council like to move forward to the arguments advanced for first issue, Your Lordships. Much obliged, Your Lordships. Since taxation being a compulsory exaction of money by public authority for public purpose, enforceable by law, it is not mere payment for the service rendered, Your Lordships. In the present matter, they are the legitimate taxpayers in this particular country. Since the matter of taxation has been invoked here, the respective taxpayer cannot expect anything in return for the tax money which they have been paid, Your Lordships, which has been held in a catena of cases beginning from Commission of Hindu Religious Endowment versus Sri Lakshmindra, Tirtha Swamiyar of Sri Shirurmut, as well as Srinivasa General Traders versus State of Andhra Pradesh, Your Lordships. In this particular matter, the two tests has been laid, Your Lordships. First, if the particular levy falls under common burden, and secondly, if the particular levy is for primary and essential purpose that come under the purview of taxation, no element of quid pro quo will be applicable, Your Lordship.
Yes, Council.
Your Lordship.
Does it come under the primary or essential? Because whatever manifesto you frame, now you are very much interested to execute. Do political party or party who is in power have a source to provide all needs whatever you promised?
Much obliged, Your Lordships. Your Lordships, in this regard, the Council would like to differentiate between a political party and state involved on the basis of election, Your Lordships. When such a thing has been announced in an election manifesto, that is
the election manifesto framed by the political party or party which is in power as a state.
Much obliged, Your Lordships. When it is election manifesto, they will be very concerned about political parties. But after coming into the power, they are the respective government of the state, Your Lordships, as well as the union.
Okay. When you made your manifesto, do you have any data how you will promise when you sit as a power as a state?
Pardon, Your Lordship.
When you want to implement the manifesto, after taking a power, have you come across any source of income to provide?
Much obliged, Your Lordships. Your Lordships, in this regard, the matter of welfare of the society and welfare of the people is concerned the present matter, Your Lordship. being a government, being very particular in the policy decision for the promotion of welfare of the society, the respect of state government involves here in providing welfare schemes, your lordships. And while coming to the interpretation of the term freebies, the Lord Friend Councils of the petitioners have misinterpreted that something which involves political nature. But the meaning of freebies is something which has been granted at free of cost, your
Is
lordships.
it the welfare means or is it an essential?
Your lordships, while coming into the essential as well as welfare, the standard of living has to be taken into consideration, your lordships. What has been once luxury now become essential, lordships, and which the council like to rely upon the Subramanya Balaji.
To these freebies are listed any one of directives of Parambara Constitution.
Much obliged, your lordship. With regard to directives, Article 38 is very clear enough for promoting welfare of the society, your lordships. In this mere sense, the council like to quote also your case, namely Deepak Theatre Duri versus State of Punjab and others, your lordships.
No, question is very simple, council. Do these freebies are listed any one of the articles of Parambara Constitution?
Your lordship, the particular element of the freebies has not been in any of the articles.
Then do you describe this as a welfare means?
Much obliged, your lordship. Since it being the policy decision of the executive, your lordship.
No, I am not coming to whether you are providing with a law or policy. Please answer the clarification directly, then we will jump.
Much
Is it because of law or policy?
Much obliged, your lordship.
When these things are not listed in the directive principle as Parambara Constitution, could you call them as a welfare means?
Much obliged, your lordship. Your lordship, the council most humbly submits. These are socio-economic development which are mainly connected.
Which article of Parambara Constitution says?
Much obliged, your lordship. Now the council like to link Article 38 of the Constitution along with Article 21 of the Constitution, which is fundamental.
No, don't club both. 21 is enforceable, 38 is not
Much obliged, your
enforceable.
lordship. In this regard, the council would like to make particular note of a case that is CEST Limited, your lordship, versus Subhash Chandra Bose.
I don't want a judgment, whatever we gave our interpretation. Start from your TPS. Is there, when you want to establish to the honorable bench as a welfare means, you can trace only from the Parambara's Constitution.
Much obliged.
Do you have any article to substantiate?
Much obliged, your lordship. Your lordship, the council most humbly submits that the respective element of freebies has not been present. However, they amount to the welfare of the society under Article 38, your lordship, which in connection with the fundamental rights become enforceable before this honorable court under the light of CEST judgment, your lordship.
So your council want to make it very clear, these freebies item you have listed are not listed in the Parambara's constitutional article.
Indeed, yes, your lordship.
Yes, please.
Much obliged, your lordships. Your lordships, in this regard, the council have already clarified about the element of quid pro quo involved in the present matter. And secondly, these previous system aims only at the welfare of the society, your lordships, only aims at the socio-economic development and eradication of the poverty in light of Article 38 as well as Article 21 of the Constitution, your lordships. Your lordships, moving further, the council also would like to claim that there exists a judicial restraint in with respect to the policy decision of the state, your lordships. Much obliged, your lordship.
Can any particular political party bribe voters for the votes?
Pardon, your lordship.
Can any political party bribe a voter for getting votes? For getting votes, can any political party bribe a voter?
Indeed, no, your lordship. That is strictly corrupt practice under Section 120.
If that is so, can they promise?
Much obliged, your lordships. Your lordships, in this regard, the council would like to derive attention from the case of Subramanya Balaji versus Government of Tamil Nadu and others, which clearly states that these promises will not be entitled as corrupt practice.
How many judges brought that?
Your lordship.
How many judges were authors of the judgment?
What is the quorum of the judgment?
Your lordship, the council seeks the help of the researcher in this regard, your lordships. Your lordships, in this regard, there exists a judicial restraint with relevant to the social matters, your lordships. Your lordships is a two-judge bench, your lordships. Much obliged, your lordships. Your lordships, considering the same, there exists certain things for the reason which the respective promise given in the present matter will not be entitled to corrupt practice, your lordships. Firstly, being a political party who intend to be a government to serve the welfare of the state, they have to make clear what is their objective, your lordships. That is what the respective political parties have also stated.
Objective is to bribe the voters, no?
Indeed, no, your lordships. Your lordships, the council is very clear of the fact regarding the welfare of the society, your lordships. It will not qualify as a corrupt practice under Section 123, your lordships. Since political manifesto itself involves and the people wants to know what the respective party is capable of doing and what the party will do to the people after it becomes the government, your lordships. Which are your lordship?
The regulation for this so-called freebies, can you give anything? Can you promise anything? Can you promise say drugs, for example? Can you promise alcohol, free alcohol? Is it possible? Is there any regulation, restriction for this so-called freebies or anything you can give? And if there is a regulation, how do you plan to see that it is properly implemented?
Much obliged, your lordship. Your lordship, in this regard, the council had to differentiate the matter of freebie and welfare scheme, your lordship. Since the moot proposition is defining the term as freebies, it doesn't mean those freebies will not qualify as the public purpose, your lordship. They will not qualify.
Council, that's what bench made it very categorically in the beginning. When you could not establish these are welfare measures under DVSP, then how you will repeatedly describe all these are welfare means?
Much obliged, your lordships. Your lordships, being a state, it is the responsibility of the state to promote the welfare of the society. Not only under Article 38, we have Article 39 substantially equalizing
when you political parties made a manifesto, you made the circulation of these freebies when you becoming a power or when you about to become a power.
Oh, pardon, your lordship.
All the manifesto, whatever you have circulated, in order to bribe or buy or attract or catch any face you can add. Was it before you took a power or after you taking a
No,
power?
your lordship, after the respective political party coming into the government, the respective system, the respective welfare schemes have been provided.
Then why
to
the learned councils of the petitioners said, even election commission failed to regulate? When you are in power, where is the question of election commission in the name of what they say?
Your lordship.
Code of conduct.
Much obliged, your lordship. In this regard, the burden lies on them to do the same, whereas they failed the same, your lordship, with regard to the election commission. And the council would also like to highlight the fact that the respective councils of the petitioner have not impeded election commission as a respondent of this matter, your lordship.
Already that's what brother said.
Much
All the
obliged.
procedure you declare, you make a substantial thing.
Much obliged.
Also, the question which I asked was, how do you qualify that this is permitted as a promise by the political parties? This is not permitted. You cannot have a free hand for everything, is it not? So how do you plan to regulate? Everything has to be regulated. Nothing can be free. Free speech is also not absolute, is it not? Right to right position. Therefore, why can't we intervene?
Much
So we are
obliged.
not regulated.
Much obliged, your lordship. Your lordship, in this regard, the government have various schemes, your lordships. Let's take for an example of public distribution, your lordships, which is ration card. We have certain things to be provided for certain people based on categorization, your lordships. Since all these are policy decisions and schemes introduced by the respective executive of the government, your lordships, it doesn't mean there is an absence of regulation on the whole, your lordships.
Council,
Much obliged, your lordship.
public distribution system is a part of your welfare means. You have your agency who can make a data and say, like this, to provide whatever freebies are listed. Is it of TV? Is it of water? Is it of electricity? Is it of bicycle? Is it of grinder or mixie or 1,000 rupees? Do you have any data too?
Your lordship, the
Because the learned councils of the petition categorically said, since you have to substantiate, now burden is yours.
Much obliged, your lordship. Your lordship, in this regard, the council would like to reiterate a fact that at present we don't have any data with relevance to the respective distribution of the particular things, your lordship. However,
When you don't have a data, isn't it not the mandate of the constitutional bench? Simply check whether you are running the government or ruling the government.
much obliged, your lordship. Your lordship, in this regard, we have various schemes, your lordship. That is the reason. All the introduction of the previous system, let it be color television, bicycles, mixer grinder, table fan, etc. All these are policies and schemes introduced by the respective government, your lordship, for the welfare of the people, your lordships. Much obliged, your lordships. Your lordships, in this regard, the council like to conclude on the fact, in the absence of quid pro quo between the taxpayer and public authority, the respective petitioners cannot claim the right to question appropriation of the taxes.
They haven't made any word called appropriation. What they mentioned, since you have diverted the public money after making burden of a group of community or category, you are enjoying whatever you have promised.
If we know, your
It
lordship.
indirectly violates the duty what you have by referring Article 40, 41, 42, 43, 44, 45, 46 and 47.
Much
What is your
obliged.
answer?
Your Lordship, in this regard, the council would like to clarify your point that all these taxpayers are also enjoying such welfare scheme provided by the government, Your Lordship. Your Lordship?
Do we have any data to substantiate? Are you giving collecting to all people who are paying tax?
Indeed, no, Your Lordship. That is the reason why the council is again and again reiterating the fact that we have separate policies in this regard, Your
Do you have
Lordship.
any proof that the person who received color TV have voted for a particular person?
Oh, pardon, Your Lordship.
The beneficiary has voted for a particular party. Do you have any data?
Indeed, no, Your Lordship.
Okay, proceed.
Your Lordship, does the council like to conclude that the taxpayer has no right to question the appropriation of tax money, and now the council takes permission to begin with the arguments advanced of second issue. Much obliged, Your Lordship. Your Lordship, the second issue is that whether the 101 constitutional amendment violates the basic structure of Parampara Constitution, Your Lordship. Your Lordship, the council on behalf of the respondent most humbly submits that 101 constitutional amendment does not violate the basic structure of the Constitution, Your Lordship. Your Lordship, preliminarily, this GST Council aims at fostering cooperative federalism of the country, Your Lordship. Your Lordship, the composition of this GST Council under Article 279A comprises both the representatives of the central government as well as the representatives of the state government, Your Lordship. State government on the whole of two-third matter, Your Lordship. In this regard, it involves only cooperative federalism, and to further substantiate, India being a sovereign country, it is divided into different forms such as center and state in each. However, each house have its independent power in terms. However, while coming to achieving the constitutional goals, these two houses has to join together to work for the cooperative federalism, Your Lordship. In this regard, this is what happened. Also, in the case of 101 amendment, where 279A is very clear enough that the respective council consists of the representatives of state government as well as central government, Your Lordship.
Their clarification is not. Their submission was when you made constitutional amendment in order to introduce 279, have you strictly followed the constitutional principles and basic structure?
Indeed, yes, Your Lordships, the respective 279A is even an example of the basic structure of cooperative federalism, Your Lordship.
Referring what entries of your list you made this law?
Pardon, Your Lordship.
Referring what constitutional entry this particular law was made?
Much obliged, Your Lordship. 246A, Your Lordships, which gives power to the respective central government as well as state government to legislate on the particular interest.
So till 2017, the Indian Constitution was in the cooperative. Because of introduction of 246A and 279, this is the cooperative federalism.
Indeed, no, Your Lordship, the council is not claiming the same. But what the council is trying to reiterate is that even after 2017, by the advent of 101 constitutional amendment, the respective GST council and also the respective provisions foster cooperative federalism, Your Lordship. Your Lordship,
The same constitutional amendment, does it violate entry 52 of list 2? When your answer is cooperative federalism, what is your final say on this?
Your Lordship, the council takes 2 seconds to
Entry, yes.
Much obliged, Your Lordship. Your Lordship, the council accepts the fact that entry to 52 has been omitted, Your Lordship. But what happened?
Yes. Here because of omission, do it or does it leave for cooperative federalism or competitive federalism?
Your Lordship, the matter here is the council accepts the fact of repealing entry 52 from the state government. However, by the insertion of Article 246A, it vests simultaneous power both on the central government and state government, Your Lordships. And when it comes in case of 246A, it has a non-obstance clause to the 246 as well as the 7th schedule in this regard, Your Lordships. Your Lordship, the council is also much...
Through this amendment, have you introduced any other entries in the concurrent list?
Your Lordship, the concurrent list is not so much concurrent. However, we have amendment with relevant to the central list, Your Lordship, as well as with the insertion of 246.
Without an entry, how you council is submitting, even they have an authority to enjoy 246 capital A.
Pardon, Your Lordship.
Without an entry in the concurrent list, how you are assuming the state can make laws enjoying 246
Much
capital
obliged, Your
A?
Lordships. Your Lordships, in this hence the council would like to direct the bench attention to the objective on which the GST amendment has been taken into consideration, Your Lordships. Due to the cascading effects of taxes before 2017, as well as the diversified tax structure in the country, the GST has been implemented with an intention of unified system, Your Lordships, with an intention to promote the federalism of both the states, Your Lordships. Your Lordship, the council is also very much obliged to quote some of the cases, Your Lordships, such as the council to exterminate the country. Much obliged, Your Lordships. Union of India versus Mohit Minerals Private Limited, Your Lordships. In this particular case, the Honorable Supreme Court has held that the GST Council is an important focal point to foster federalism as well as democracy, Your Lordships. Your Lordships, further moving. Your Lordship, in year 2022, Your Lordship. Much obliged, Your Lordships. Additionally, the fiscal federalism of the fiscal autonomy of the state has also been guaranteed in the present matter. In the lights of the case, Mineral Area Development Authority and another versus.
Council, what is the vote sharing power or vote power of the
Much obliged, Your
Union
Lordships.
States in the GST Council?
Much obliged, Your Lordship. In the GST Council, 3/4 of the majority has to be proved, Your Lordships. In this regard, 1/3 of the power vests with the central government, whereas 2/3 of the power vests with the entire state
That
government.
itself is sufficient to show it is not promoting federalism. 1/3 vote share is given to center, and only 2/3 given collectively to the states. The center can effectively have a major say in all the decision making. Number one. Number two, suppose a state is not happy with the GST Council decision. What is the remedy available in law?
Much obliged, Your Lordship. Your Lordship, with regard to the first question of this honorable bench, the council would like to reiterate the fact that in the ultimate concept and the majority and the power given to the central government and state government simultaneously is an example of cooperative federalism in this regard, Your Lordships. Since the recommendation made by the GST Council are not binding on the state, it is evident that the cooperative federalism will be promoted. If we say in case, if the GST Council's recommendations are binding, then it will have its detrimental effect over the cooperative federalism. But according to the judgment of Union of India versus Mohit Minerals, the recommendations by the GST Council are mere recommendatory in nature, Your Lordships. This is in such a way, this recommendation fosters cooperative federalism, which has also been held in the case of Union of India versus BTC Footsteps India Private Limited, cited 2021 INSC 469, Your Lordships.
Good to see a state can disagree with the GST Council decision, apply separate rates to that state.
Pardon, Your Lordship.
Suppose a state has not agreed with the GST Council decision, can it apply a separate set of rates, GST rates?
Indeed, no, Your Lordship. In this regard, respective mechanism for the dispute resolution has been given under the same
What is my
provision.
question? What is the mechanism?
Much obliged, Your Lordship.
Again, the GST Council has to decide the mechanism. Where center has got 1/3 votes.
Pardon, Your Lordship.
The dispute resolution mechanism is, which has to be decided by the GST Council themselves. What is the mechanism? Again, where the center has got 1/3 votes to decide what is the mechanism.
Your Lordship,
So
even
always the state is a
much obliged, Your Lordships. Even that being the case, this is where the recommendatory nature of the recommendations made by the GST Council has to be taken into consideration, Your Lordship. Since they were not binding in nature, it will promote cooperative federalism. It will also protect the federalism as well as fiscal autonomy of the state, Your Lordships. This is what the Council would like to place before this honorable court. Your Lordships, and additionally, this system also aims in promoting economic justice, Your Lordships. Thus, on the whole, in the issue number 2, the Council most humbly summons that there is no violation of basic structure in the present matter, since the federalism has been fostered by the 101 constitutional amendment.
Council,
Much obliged, Your
my
Lordship.
brother has asked with regard to the dispute resolution mechanism. The GST, if there is a fight between the two, a state and a center, or between two states. Now, the present mechanism is the GST Council will resolve the dispute between the two states or with the center and state. The power of Supreme Court is taken away in dispute resolution mechanism of the Act.
Much obliged,
Whether
Your
it
Lordship.
violates fundamental
Indeed, no, Your
doctrine.
Indeed, no, Your
Yes,
Lordship.
on the Saudi doctrine.
Much obliged, Your
Fundamental
Lordships. Much obliged, Your Lordships. In this regard, the Council, I would like to again reiterate the fact of the judicial restraint of this Honorable Supreme Court with relevant to the matters taken by the GST Council, Your Lordship. There exists a judicial restraint with relevance to the interference of the matter as decided by the GST Council, Your Lordship.
Council,
Much obliged, Your Lordship.
when the question of judicial restraint comes, whether the subject what you council is presenting, is it a decision based on a law or policy?
Pardon, Your Lordship.
The presentation what you are making or submission what you are making, is it based on a law or policy?
It is based on the constitutional provisions, Your Lordship.
Constitutional provision. Then where is the question of restraint?
Much obliged, Your Lordship. In this regard, when it goes against the principles guaranteed by the Constitution, as well as when there is a sincere violation of the fundamental right being involved, this Honorable Supreme Court is entitled to involve in the matter, Your Lordship.
We have to be mindful of the fact that judicial restraint is self-imposed one.
Much obliged, Your Lordship. The Council is about this one. Same, Your Lordship. Your Lordship, thus on the court, the Council like to conclude that the 101 constitutional amendment will foster cooperative federalism and will not have any detrimental effect over the basic structure of the Constitution, Your Lordship.
Don't say force will facilitate the cooperative federalism. Will facilitate the cooperative federalism. Don't say force.
Much
Already there.
obliged, Your Lordship. This gives an immense pleasure to argue before this honorable bench. Now the Council like to invite my co-counsel. Much obliged, Your Lordship.
Council, how many seats permission? Yes, Greetings to the bench. Council humbly seeks permission to address the bench collectively as your lordships. Much obliged, your lordships. Council is always here to present on the issues of number 3 and number 4, in which issue number 3 is whether the levy of GST at different rates violates the fundamental rights. It is humbly submitted by the Council for the respondents that there is no violation of fundamental rights by the levy of GST at different rates. For this, the Council would like to state that such slab rates, which is respectively that 0% of tax for certain goods and services, and 5%, 12%, 18%, and 28%, and also 3% on tax on certain matters, and also with 0.25% on certain matters, are all decisions of the executives involved in this matter. So it completely comes in the administrative matters, which has a specific mechanism under the GST Council relations. For this, the Council would like to rely on that mechanism involved inside the GST Council. That is, GST Council consists of a committee, which is the Fitment Committee. Fitment Committee contains the members of both the state government and the central governments, which contains of joint secretary to co-convener commissioners of GST, and with regards to the state governments, each state government represents their state tax commissioners respectively. So all those members are the members of the Fitments Committee. So Fitments Committee suggests the rates. So actually, it is the standing committee which contains various committees by the government, which contains Law Committee, Information Technology Committee, and Single Interference Committee, among which one of the committee is that Fitments Committee. And Fitments Committee's duty is to set upon tax rates. So for this, the Council would like to state that from where does this Fitments Committee derives the power to set upon the rates, or on what basis it is setting upon the rates or different kind of slab rates for the goods and services that is being provided by the government. So for this, the Council would like to rely on section 15 of the Central Goods and Services Tax, and also, apologies, Your Lordship, section 9 of the Central Goods and Services Tax, and also with respect to the section 9 of each and every state goods and services tax. And also, with regards to the interstate goods and services tax, section 5 is the levy and collection of taxes with regards to how the procedure is being established. For this, the Council would like to rely on section 15 of the central government's GST Act, which states that the value of taxable supply. For instance, the Council would like to state that the difference of 0%, 5%, 12%, 18%, and 28% are on the basis of such that incidental expenses including commission and packaging are charged by the supplier to the recipient of the supply. So there are certain elements of technicality.
Council section 15 talks about valuation of the goods
Indeed,
or
Your Lordship.
services. We are not on the question of valuation here. There is the question of rate of tax. Rate has to be levied on the value. Suppose value of this is 10 rupees, 18% on this. That's it. So we are not on the value of the goods. Section 15 deals with valuation of the goods. We are dealing with rate. How can you have different rates for different goods, unmindful of the fact of without taking having any regulatory or policy mechanism to find out what kind of goods are essential, what kind of goods are required for the common man, what kind of goods are luxury goods, is there any differentiation of them with respect to the goods? Before levying a rate of tax, or based on the recommendation of the state tax commissioner and the joint secretary are taking a decision, who are bureaucrats, they are not experts in finding out whether a particular class of goods are required for a particular class of the citizens like middle class or the lesser privileged persons. Is there a mechanism to find out how the goods should be classified so as to levy appropriate rate of tax depending upon the ultimate usage of the goods by the common man or by the privileged person?
Indeed, Your Lordship.
Yes, Counsel. As your learned counsel was mentioning, you are providing all welfare meals. You have a duty to provide health care. For health care, you need a water. For water, you are charging 18%. Gold, ornament, diamond. Only selected top class people will go, where you are charging 3%. What is the rationality? Do you have any data by managing? What is the percentage each and every item compartmentalizing, as your learned counsel was mentioning, essential for or needs and wants? Do you have any data to substantiate? Please answer to our brother.
Indeed, Your Lordships, for the questions raised by the bench, the council is obliged to answer. That is, with regard. It is submitted that this is based on the scope of the markets which involves those goods and services respectively, Your Lordships. It is because, for example, for the question raised by the bench with regards to ornaments, which is only taxed at 3%, the market rate or the market value of such ornaments are fluctuating in nature. So that it is to be determined that even though only certain people or the people who are eligible or who have a higher income in their value, they are not contesting or they are not denying that every people sorry for the inconvenience, Your Lordships. The section is that the council would submit these are certain matters which is dependent on the market value of certain goods and services which are taxed at different rates. And for that, the mechanism involved is that the members of the state or the central government, with respect to the financial experts who are dependent or who are experimenting that these goods taxing at different jurisdictions.
The respondents intended is to have a capital market and that of a welfare means, right?
Indeed, not, Your Lordship. It is
people used to think more, therefore we will charge many. Then people will not buy gold, then we will charge less.
Indeed, not, Your Lordship. Indeed, not, Your Lordship. The council intended to say that these goods and services.
No, since you council said based on market, that's what. Are you running a socialist government or a capitalist government?
Indeed, socialist government, Your Lordship. There is no denial on that point. So the council tries to insist on the point that certain goods and services being taxed at different slab rates, it is because of the nature on other goods made and the processes involved in this, and also the import and exports of certain goods. With respect to
What is the process involved in selling a water? Water is a national commodity.
Indeed, Your Lordships. However, the packaging of water is a process that is involved in providing such water, Your Lordship. The council is not denying or the council is not saying that the water is not completely exempted. But the packaging of water and the certain elements of certainly scarcity or whatever things that is being involved in processing such water to bring it to the market makes the government to mandate that
If
such.
government wants to submit, you have a scarcity, then you want to discover an alternative to provide. How you will charge 18% to provide a basic amenity like water?
Indeed, Your Lordship, with respect to water, it is
Okay, as our brother counsel, judge was asking, what is the rationality? Have you come across any expert advice by saying these particular slabs can be followed, whatever market demand you have?
Your Lordships, the council submits that for which the slab rates to be determined as already submitted by the council. It is the Bitsman committee which comprises of members of the group of members which is the GOM
contains of the group of members, where the group of members are the financial experts or the administrative authorities in the group of members, which is a part of the Pitmans Committee. Pitmans Committee comprises of various members, in which already stated as the members from the central government and the state government. Also, it contains a GOM. GOM is the group of members which contains the expert members who are having the analytical data of what goods are to be taxed at what jurisdictions, or what are the relevant values of change that is occurring on certain goods with regards to the change of time, Your Lordship. So therefore, with regards to water, the specific question on water, it is the submission that water is taxed at a different rate or taxed at a higher rate. It is because of
Not only water. Water I gave an example. Our Learned Council for the petitioner said even for medicines.
Indeed, Your Lordship.
Okay, even you that English medicines you are fixing less, and traditional medicine like homeopathy and all that Unani you are charging more.
Your Lordship, the Council would like to bring a difference that with regards to the English medicines, there involves the import of certain goods. So it involves service taxes. So with regards to the differentiation of involvement of such certain taxes, there can be
Council,
Indeed, Your Lordship.
fixing of rates is the prerogative of the legislative function. Can the legislature transfer this power to executive council, that is GST council, to fix rates?
Your Lordship, the Council would like to bring a difference that legislative power can provide the power to the executive on fixing such rates, since being the executive has the expertise in this particular matter to fix such rates and say the reasonable, fix it in a reasonable manner.
Income tax rates are fixed by whom? Whether executive or legislature?
It is the legislature which provides for Income Tax Act.
Legislature only provides.
Indeed, Your Lordship.
But in GST, the legislature has extended the power to the executive, that is the GST council, to prescribe rates. Right?
Indeed,
It
Your
is
Lordship.
not violative of basic structure of the constitution.
Indeed not, Your Lordship.
Well, I will rephrase. Are you authorized to delegate essential function?
The Council would like to submit that the delegation of power is a matter of the legislative body, and the legislative body can be delegated since because delegation of powers are certain matters that has been observed from history. So,
Whether power to impose collect tax is it come under the essential function or non-essential function?
however, Your Lordship, the Council would like to state that with the growth or with the evolution of the jurisprudence of law and the economy from the year of 1991, in which LPG has occurred, liberalization, and there rises an economy, and there is an importance.
Our clarification is not why you are bringing GST. Whether power to impose and collect tax is it an essential function or not?
Indeed, Your Lordship, the Council submits that it should be considered as an essential function since because
Okay, very good. When you say it's an essential function, or as you put it, it should be considered as an essential function. Can it be delegated?
Your Lordship, the reason for the delegation is that
Can you delegate? I am not asking reasons. Can you delegate? Can a sovereign delegate the essential function like impose and collect tax?
so the Council would like to submit that. Your Lordship, the Council submits that the legislative can delegate the powers since if a proper legislation policy is laid on that particular matter, Your Lordship. If it is because it is to be implemented in a manner that
Isn't it not a violation of delegate as non-protest delegate?
indeed not, Your Lordship, there is no double delegation involved in this particular
I am not
matter.
asking double delegation. Delegate as non-protest delegate. Okay, continue.
Indeed, Your Lordship, the Council submits that delegation is a mandatory power, or it is to be essential. It is to be essential in this particular matter since because it involves the expertise of the financial experts involved in the Fixments Committee, so that it becomes reasonable. So, Your Lordship, the Council submits that it is an important element to be considered since because it involves the expertise of the administrators involved in this particular matter. Also, proper legislation policy should be implemented by the legislature so that the expertise of the administrators will be determining the tax slab by the members of the department which is inside the GLCTRY Council as already mentioned by the Fixment Committee, Your Lordship. So, therefore, the Council submits that with regards to the tax slab rates determined by the fixed committee, there is a reasonable nexus or intelligible differential in determining such tax slab rates, since because it involves the value of exchange and it involves various aspects such as the import and export and also the jurisdiction of whatever area, what are the areas that is being distributed throughout the nation, Your Lordship. So therefore, the tax slab rates are not violation or are not in violation of any of the fundamental rights of the Constitution, Your Lordship. If the bench is convinced, the Council will be proceeding with issue number 4. Indeed, Your Lordship, much of it. Issue number 4 is whether the levy of both income tax and GST violates the economic interest of the nation. The Council submits that the levy of both income tax and GST doesn't violate the economic interest of the nation, Your Lordship, since because both income tax and the GST are essential parts to bring upon the economic development and the growth of the economy of the nation, Your Lordship. Also, the Council would like to submit that with regards to the contention of the petitioners, the learned friend councils of the petitioners stating that it creates a double burden or double taxation as termed by the learned friend councils, the Council would like to submit a case in which the Municipal Council Quota Rajasthan versus the Delhi Cloth and General Mills Company Limited, which says that wherever the taxes imposed by different legislations or authorities, or when one of the two is also a tax and where it is for altogether different purposes, there is no scope even for making any grievance for double taxation. Here, the Council would like to bring the difference. The Council would like to also submit the compendium for the same, for the reference of the bench. So, the Council is relying on this judgment since because it states that two different legislations imposing two different taxations cannot be a ground for asking of grievance, that is imposing double taxation. Here, the two different taxation is that income tax is legislated by the Income Tax Act, while the GST is legislated by a different tax, which is respectively the central GST and the state GST, and followed by the interstate GST. So therefore, the two different legislations imposing two different taxes cannot be a ground to say that there is a double taxation, Your Lordships. So therefore, the Council says that there can be no ground for raising the double taxation needs, Your Lordship. And also with regards to the importance of income tax to be not repealed entirely, the Council would like to state that there is concept of fiscal harmonization, which is an important objective to for the growth of economic development of the nation, Your Lordship. So the Council would like to rely on a simple question or a simple fact, that is even before the introduction of GST. Also, Your Lordship, the Council would like to enumerate a fact that, or enumerate the statistics that income tax has contributed about 54% of the...
No doubt the law is clear that two aspects of it, but this slightly going out of the syllabus, so to say, GST, as far as GST is concerned, are you aware that after the introduction of GST, litigations in GST has exponentially increased? Huge litigation, every assessee is being sent a notice on procedural grounds. So even though the issue here is slightly different, what I'm trying to drive home is the introduction of GST by the government or by the parliament is in such a way that a common man, a businessman is being seriously affected. When forget his income, the income tax what he is paying, he is not able to generate income because of the random and indiscriminate issuing of notices under the GST Act. So this is actually, even though the issue here is different, what I want to answer is, are you aware that there has been indiscriminate increase of litigation under GST, and if so, is the government doing anything to ensure that the litigations decrease? What are the policies being introduced to ensure that the common man is not affected because of this procedural issues being raised in every aspect under GST?
Indeed, Your Lordship, the Council would like to submit that with regards to the income tax on one hand and GST, as the bench quoted that there are litigations with regards to GST. Also, the Council would like to submit that government is aware that there are problems when a new concept of any economy comes into the nation. And also, the Council would like to rely on a judgment which has...
Have you introduced any amnesty scheme? Have you introduced anything to ensure that the initial hiccups of GST people are insulated from the initial shocks? Have you introduced anything to...
Your Lordship, the Council would like to state that there may be discrepancies with regards to GST at the very initial stage. However, the Council would like to rely on a judgment which is of RK Garg versus Union of India, that is, every legislation, particularly in economic matters, is essentially empiric and it is based on the experimentation. or what one may call trial and error method, and therefore it cannot provide for all possible situations or anticipate all possible abuses. So there may be crudities and iniquities in compliance experimental economic legislations, but that alone cannot be a ground to shut down as invalid, Your Lordship. So the council would like to rely on this judgment. Can I proceed with the So the council would like to state that there may be discrepancies with regards to legislation on economic matters. So it has to be rectified by the government, and the government is very aware that, and it is producing every amendments with regards to notifications provided by the GST Council, and it implements everything that is being observed by the nations that is being affected, or that is being violation, or that if there is any kind of discrepancies with regards to the GST Council is well aware, and it is implementing such nature through notifications where, for example, certain elements, certain goods and services are taxed at different rates, since observing the nature of how that goods and services market is being fluctuating in the nation's budget. So with regards to that, the council, even for the same, the council would like to state that there is recent development that with regards to, as the petitioners council stated, that the life-saving drugs are imposed with a tax percentage of 5%. Even the government is now considering it to reduce again at 2%, since considering the nature of the importance that how life-saving drugs are to be noted, Your Lordship. So therefore, the government is very aware to say that these goods and services are to be taxed at different rates as it evolves, as the time evolves. So we are not very well aware, or we are not unaware of the fact that it affects the people, or we have a separate grievance mechanism system. Also we have the expertise, and also we involve both the central and state governments to involve in the matter to decide upon the tax rates fixed, Your Lordship. And with regards to the income tax, the council would like to rely on a simple fact, that is, even before the introduction of GST, there was certain indirect taxes with respect to service tax, excise tax, customs tax, and whatever. So the council would like to state that even before the introduction of GST, there was income tax at one end. The council would be concluding within 2 minutes if the bench permits. Much obvious, Your Lordship. So even before the introduction of GST, there were income tax on one hand, which was paid by the taxpayers, and on the other hand, there were indirect taxes, which created the cascading effect as observed in the history. So the government introduced GST, consolidating all the cascading effect.
Council, two clarifications. If at all you want to make laws in order to cope up the international commitment, the LPG came 1991, right? You made a law in 2017, right? From 2017, do you have any statistics? The different layer of taxation, whatever imposed and collected, is giving some economic prominence. Because according to Tamrami, whatever you are imposing and collecting, you are not putting for national growth. You are actually diverting to satisfy some of the people who ever casted vote for a party, whoever power. So how you will substantiate the imposition of the same, give some prominence of economic?
Indeed, Your Lordship, the council would like to bring the attention of the bench to page 25 of our memorial, where we have placed the statistics in point 14. Which states that the total revenue realization from both direct tax, which is income tax, and the indirect tax, which is the GST, increased from 6,032.61 billion in 2008 to 9, and with respect to this statistics, the council submits that the involvement of both direct tax and the indirect tax promotes the economic growth in the nation, Your Lordship.
Okay. Do you have equal statistics of what is the healthcare expenses, what is the electricity expenses, what is water supply, whatever housing, whatever urbanization, whatever road, train, transport, civil aviation? These are welfare means.
For this, the council now seeks apology, since there is a lack of statistical data right now at the moment.
Then how you will make a submission by saying whatever you are imposing and collecting lead for economic development, then that are making a heavier burden to the taxpayers. That's what a convention made by the learned councils of the petitioners.
Sorry for the information, Your Lordship. The council submits that this particular GST and income tax together is not of the nature, or is not of the sense that it is to abridge the taxpayers, or it is to become a burden on the taxpayers, Your Lordship, since as far as statistics is concerned, it says that the collection of both direct tax and income tax is amounting to the economic growth. So therefore, the lack of certain statistics at the moment with respect to the taxpayers associations, which is contention raised that it is not appropriately used.
No, council, your co-council also rightly mentioned, no taxpayer have an authority to take any question on how much it is collected and spent. But the simple question, when it is reaches us, to check whether the money whatever you have collected is spent for the political manifestos compilation or welfare means.
Indeed, Your Lordship, for this the council could submit that it is not only solely reliant on the whole consolidated fund of India, which is collected through both direct and indirect taxes, or not only. So, it are not only invested on political parties' manifestos, Your Lordship. The council would like to bring the attention of the bench para 11 of the proposition, in which it states the service sector's share of global GDP increased from 53% to 67% from 1970s to 2021.
No, amount you have collected is increased. Whether is it diverted for a welfare means? That's the question. We are not questioning have you received any extra money. Yes, statistics says you have received an extra money. Where you are diverting? Are you diverting for a public means or welfare means or to give freebies in order to satisfy the electoral manifesto, whatever you pay?
Indeed, Your Lordship, for this the council says that it is the formal duty of the state to invest for the welfare of the people, Your Lordship. So therefore, it cannot be contended that the state has not invested it for the welfare of the people, or since the fact is very silent on this matter, that they have not used it for any of the welfare of the people. So it is an obligation which is mandated by the constitution.
Same compromise page number 8 categorically mentioned. The cost of these freebies are some states is estimated 96,000 crores or 2.2% of state's GDP. To pay for exorbitant of cost freebies, state government revised targets and physical deficit, capex and revenue expenditure.
Your Lordship, the council would like to submit that for this on this matter, with regards to GST, there is a mechanism of input tax credit, Your Lordship. So, and also for the states, if the states are affecting by the loss, or if has any revenue loss, there is a mechanism alternatively given by the legislation, which is the goods and service tax compensation cess rules. So, which provides for allocation of compensation to the states, which is.
Because your learned council mentioned you are a cooperative organism. We are not at all questioning how you are going to compensate. What all relief you are giving to the state whoever affected. Our simple botherization, since they came up with Article 32, the question of hue and cry of violation of fundamental rights and freedom, we are the constitutional court as a custodian of a constitution have to take care of the welfare of the people. Whether money you have collected is literally diverted for a welfare means or to complete the election manifesto. Because our learned council also submitted policy decision, we will not interfere. Yes, we are not at all. Because we have a strike. But the money, is it collected from the people, spent for welfare means or not? Because most of the lines from the compromise says, you provide everything, it's not at all good quality, it's defective. Then indirectly shows the money goes to the political party packets and that are welfare means.
Your Lordship, for this, the council would like to rely that the report submitted by the Comptroller and Auditor General of Parampara, which says that there is a lack of quality or there is a poor quality of service, cannot be admitted before the court of law, as has already been, it has been declared by this same court that CAG report cannot be considered as an admittable document in the sense.
Alright, about the CAG report, leave it. What about the RBI repeatedly warning the government about the fiscal deficit? What do you say about that?
Pardon, Your Lordship.
RBI is repeatedly warning about the fiscal deficit increasing on every monetary policy. Have you taken into consideration that?
Your Lordship, the council submits on all the questions raised by the bench that is, it has been spent for the public purpose, Your Lordship. The deficit fund cannot be a reason to deny that welfare, it has not been spent on the welfare of the society, Your Lordship. So, the deficit fund being questioned or being criticized cannot be a ground to say that these grounds are the tax-paying money which is collected by the government is not spent on the welfare of the people, and it is only spent on the grounds for political purpose. It is to be submitted that it cannot be a ground to say that it is not wholly spent only on public purpose, that is political purpose. So it is submitted that we have spent for the welfare of the public, Your Lordships. So that cannot be raised as a ground. Since there is only the fact which says about the deficit and the fact is silent on the matter that whether it has been implemented for the welfare of the people. So that cannot be a sole ground to say that we have not invested for the welfare of the people here also. So if the bench is convinced, the council will be proceeding with the prayer of the.
So it's not mentioned in page number 2 and paragraph 9, paragraph says that report by Nidhi Aayog criticized and reviewing is the state from the diverted funds. So, time is exhausted.
Your Lordship, those are matters of only criticism. Your Lordship, the council submits that those are only matters of criticism, which is the NADB is only criticized that it has not been used, and with regards to the CAG report, it cannot be.
Believe that Nidhi Aayog is a body what you have created. So they can't criticize. They based on that report only you have to move forward.
Your Lordship, the fact is very clear that there is no report by the NIPP. It has only criticized that the PPs such as laptops. Whereas CAG only has submitted the
Oh,
report.
that's what. What is the status of Nidhi Aayog?
However, Lordship, Nidhi Aayog's report is also not binding in this court of law, so that it cannot be considered to be an admissible document with regards to the same matter. If the bench permits, the council will be proceeding with the prayer. Much obliged, Lordships. Wherefore, the rights of the fact stated, issues raised, and the arguments advanced, the council for the respondents humbly pray before this honourable court to kindly dismiss the petitions and or pass any other order that may deem fit in the interest of justice, equity, and good conscience, for which the council for the respondents humbly pray. Those are not arguing before this court of law. Much obliged, your Lordships. Thank you so much.
So since I think you have excessive much of time, the rebuttal and surrebuttal for 2 minutes and 1 minute.
Lordship,
Don't repeat counsel, may very full at points.
Your Lordship, shooting the questions against the learned opposite counsels, they cited the Subramaniam Balaji case. The same case mandated that election commission should make a framework for these illegal manifestos. Your Lordship, this case was given a judgment in the year 2013. The political party which they are making representation came in 2014, and now it is currently 2025, currently 10 to 11 years. What is the stand of the parties they are representing regarding the election manifestos and the election commission's rule? And secondly, Your Lordships, they have given an exception to the alcoholic liquor consumption, but not to the water. So is that mean they are saying that alcoholic is essential and water is a non-essential benefit? And Your Lordship, that the statistical department is in the hands of government. The government fails to provide the statistics. Hence, it cannot be expected from a citizen or a layman because the government is having the Department of Statistics under their control. Your Lordship, the third figures, they are obligated to answer what is the necessity to bring back the GST. When there is no necessity, then there is no law. Under what necessity they brought the GST? If it is cascading, then what statistics shows that before introduction of GST there was a cascading effect? And Your Lordship, the government also stated that, the council stated that the essential goal was to make welfare schemes to the government. Do the government think that water is not a basic need and providing water at free of cost or free of tax is not a welfare scheme? Rather, providing alcohol at the exempted rate is an essential function of the government. At last, Your Lordship, since the Learned Opposite Council admitted that it is the essential legislative function of the government, it cannot be delegated to any other person. If such delegation is being carried out, then that is the ultra vires delegation, Your Lordship. Then that delegation should be set as a null and void. And at last, Your Lordship, the Learned Opposite would like to conclude the last point. The Learned Opposite Councils have an obligation to justify levy of both GST and income tax, because the income which I get is taken away from me in the name of GST. So hence it is a burden.
Yes. Learned Council for the respondents.
Lordship, the council seeks permission to begin with the celebrities. Much obliged, Your Lordship. With regard to the first celebrities raised by the respondent petitioners of what the election commission have did, This is what the model of code with regard to the election has been implemented only after the judgment of Subramania Balaji, Your Lordships. And secondly, the necessity of implementing such a GST is not only cascading effect of the taxes as well as the diversified structure, Your Lordships, with the intention to unify the structure as well as to promote one nation, one taxation. Such a constitutional amendment has been introduced, Your Lordships. And Your Lordships, thirdly, with regard to the matters raised for the water order, the council would like to add upon the matter of value added addition, Your Lordships. Let it be service rendered for such package or anything as mentioned by the co-counsel between the two arguments that has to be taken into consideration with the relevant matter, Your Lordships. With this, the council concludes the parliament. Much obliged, Your Lordships.
Court is to wind up.